Hey, everybody. It is Thursday evening. I am John Skiba, and so we are doing our weekly live stream here on the Consumer Warrior YouTube channel. Appreciate any of you who are watching live and who may be checking this out later. But each and every Thursday night at 5:15 p.m. Arizona time, we do a live Q&A talking about different topics from debt collection lawsuits, bankruptcy, wage garnishments, and all the other horrible things out there. So for those of you who may be new to it, I do have to give my little disclaimer each and every week that while I am a licensed attorney in the state of Arizona, I'm not licensed anywhere else. And so I cannot provide any legal advice to those of you who don't live in the state of Arizona. And really nothing I'm going to be providing tonight is legal advice. It's merely topics that we're going to be discussing. And it makes sense. I don't know the specifics of your case. We've likely never met. And so, and I don't know the laws in each state. So take it for what it's worth. This is just information on how, topics and trends and things like that I've seen when it comes to debt collection, lawsuits, bankruptcy, and dealing with kind of more serious debt problems. So the way that we do this is if you do have a question or a topic you want to discuss, you can put it there in the chat, and I will put it up on the screen. And we can discuss, provide input and some different ideas of different ways and approaches to try to handle things. Something I thought we could do tonight is if you want a question, if you could put what state you're in. That's always helpful to me because then I know if you're from Arizona, I can provide a little more background just because that's where I'm licensed. That's where I have my knowledge base is. Provide the state that you're in when it comes to answer these questions or going over these topics. So, all right, let's go ahead and, before we jump into the questions, I'm going to give you one little quick topic. You may have noticed if you're a regular follower of the channel, I recently did a bunch of videos on abusive debt collection tactics. There's a law called the Fair Debt Collection Practices Act. I've been wanting to do a few more videos on those. This is a law that really just tells debt collectors what they can and can't do. And one of the big areas that I see people, these creditors or debt collectors, violate the FDCPA, particularly junk debt buyers, is when they settle a claim with you and they fail to update your credit report and show that it's been settled and paid out. If you've settled a claim with a debt collector, excuse me, make sure, sometimes I say give it 30 days, to run through the normal cycle, but make sure that that information is updated. And if they don't update it and if they continue to report it as past due, you may have a claim against them. You can get $1,000 statutory damages plus attorney's fees and cost. So that's just a tip that if you're settling these debts out, make sure that it gets updated on your credit report. Hopefully they've agreed to delete it altogether, but if they haven't, it needs to at least be updated. So, all right, let's jump into the first question tonight, which is going to be a bankruptcy one. Hello, I love your channel. Thank you for supporting the channel. If I'm in a Chapter 13 bankruptcy case, can I change to a chapter bankruptcy? And they said they're in Arizona. Thank you for putting which state you're in. So the answer is yes. If you file a Chapter 13, or even if you file a Chapter 7 bankruptcy, you're able to file a motion to convert the case to a different chapter. Now, the only little caveat to this is you have to be able to qualify to convert to the different chapter. So, for instance, when you file a Chapter 7 bankruptcy, which is what most people file, there are income limits as far as what you can make for your family and household size to be able to qualify. So, for instance, in Arizona right now, for an individual, I believe you have to make less than $52,000 per year to be able to qualify for a Chapter 7 bankruptcy. And those numbers are changing all the time. So if you're watching this in the future, and that's not an exact number, I'm just throwing a number out there. But if you were to be in a Chapter 13 and then want to convert to a Chapter 7, you're going to have to show that you qualify based upon income. We see this a lot when people are in a Chapter 13 and they lose their job or something like that, and they just haven't been able to secure new employment. They can convert to a Chapter 7. Most people in Chapter 13s have an attorney, and if you have an attorney, just talk to them about that, some of the pros and cons to it. But the process is filing a motion to convert. They convert the case from a Chapter 13 to a Chapter 7. They give you a new Chapter 7 trustee to handle your case. They will look at your assets to see what assets can be liquidated for the benefit of your creditors. That's standard in all Chapter 7s. Most things are protected through your state's exemption laws, but there may be something to consider there before converting. You have to go through a second 341 meeting or meeting of the creditors with the Chapter 7 trustee, but then they discharge it out usually a couple months later. So that's generally what the process would be for converting a Chapter 13 to a 7. The reason why you would convert a Chapter 7 to a 13 is sometimes a trustee will go after an asset in a Chapter 7 that you don't want to lose if they're trying to sell your house or something like that. It's a situation where you could convert to a 13 and then make the monthly payments for the 3 to 5 years, depending on how much you make. So there's a lot of different kind of moving parts into it as far as what is involved. And so that's something to take a look at. And for sure, if you have an attorney, I would have them reach out and do that. So really quick follow-up. The only reason why I had to file Chapter 13 is because I have an asset and I can't lose it. And I do qualify for a 7. So that's the exact scenario I'm talking about, that if you have an asset that you are at risk of losing in a 7, you can file 13. 13 is awesome because you can keep your assets, but you have to make a monthly payment, usually for up to 5 years. But if you convert now to a Chapter 7 and you still have that asset, same thing. You're still at risk of losing it. They can still liquidate it and sell it, and it may be that you're okay with that, but that's something to take a look at. So, all right, let's see what Eli, the Barber Cape, has to say today. I just got a default by one account, but there's 5 more accounts trying to take me to court or Zoom or whatever. What can I do with a single default? So if it's a default judgment that's been entered against you on one account, and then you have 5 more accounts, then just trying to think as far as what the best way to handle that is. Because if you have multiple accounts and they've already got a default, your options would, anytime there's a default judgment, I always give a handful of options. The first one is you can try to vacate the default judgment. You got to look at why they got it, how they got it against you. Did they get a default because they didn't serve you properly? Did they not actually come to your house and serve you with the complaint and the summons? Did they serve it at a wrong address? If they did something like that, you may be able to get it set aside. If they got a default because they served you and you weren't sure what to do, so you didn't answer, unlikely that that's going to be granted. And so, but that's one of the first things I look at is there a basis to file a motion to vacate it? And by the way, I forgot to mention, I have pinned at the top of the chat here the link to the tutorials that I put out. If you want to take a look at those, there is one there that has that specifically. Marcos, I'll get back to your question, but thank you for supporting the channel. All right, let's go back to this one with Eli here. And so the other option is to try to settle it. Reaching out and offering some kind of settlement proposal to try to get that to go away. And then the third option is bankruptcy. If you have 5 more lawsuits, that's the territory that I start saying you may want to talk to an attorney about filing for bankruptcy. A bankruptcy will stop all 5 of those lawsuits. You're likely going to be able to get rid of that default. You're just starting to get into the territory where where there's so much, you get to a point where there's so much litigation that you're going to be better off often in just eliminating it through bankruptcy. So that's something to take a look at. So, all right, let's go back to Marcos. AZ, you're in Arizona. The court, by the way, it's super hot here. It's 118 degrees today when I was driving down the freeway. These are the times when I wonder why I live here. But I love Arizona, but that's still 118 is too hot. All right. So this one in Arizona, the court just denied my motion for arbitration this week. Does this usually give an indication on how the trial will go? Not usually, because the decision on whether to grant arbitration, and a lot of it will depend on whether it was a motion to compel arbitration or motion to dismiss. The court should agree to the motion to compel arbitration. It drives me nuts. I mean, this is the agreement of the creditor that they drafted up, and they're wanting to hold you to all the other terms in their terms and conditions, but that one, and then the court doesn't enforce it. I have a real problem with that when the courts, because at a minimum, the court should stay the litigation and allow the parties to participate in arbitration. To just say, no, you've got to go forward is really frustrating. So, but as far as whether that gives an indication on how the trial will go, I have I guess, biases on how I think if a judge is denying that, I'm a little worried about objectivity, but I don't know the basis for them denying it. So I will withhold any judgments there. But the trial is going to be based upon whether the plaintiff can prove their case, not whether there's terms and conditions that require to go to arbitration. So I would say no, that's not going to be an indication, because the court's going to be dealing with totally different setup there. So, all right, Muriel, good evening. Good to see you tonight. Dave, thank you for always. You are every week. You're here supporting the channel, and I really appreciate that. All right, let's see here. Let's go here with Ryan. An LLC took me to court in Los Angeles, Northern California, couldn't make it, and then haven't heard anything for 12 years. They renewed the judgment with 1 month left and put a lien on my home last month. There's follow-up that it was a credit card judgment. In Arizona, judgments are good for 10 years, and then they can be renewed every 10 years going forward. And because I recently had a client that had a judgment out of California, we actually just researched this, almost an identical statute in California. The judgments there appear to be good for 10 years, and then they renewed it. So if they renewed it timely, unfortunately, it's still a good judgment. And the problem with that is they're still just churning interest on that thing. And so you need to see if there's, I believe we even researched that there's a 10% interest rate on some California judgments. So something to, it's something where you need to try to get it settled or file bankruptcy on it to get it gone. Otherwise, you run the risk of just interest just continuing to churn on it. And then one day they're going to show up with a huge wage garnishment or a bank levy, lien the property, like you were saying, that's going to be a problem. So you need to work to try to get that one resolved. So let's see here. I'm with you, Dave. Headed out to the forest in West Virginia. I need to do that. I need to find some place to escape to during the summer. I always think it's funny. My kids grew up here. I did not. I grew up in Utah, but they don't understand all these references in songs and popular culture that summer is this great time, because it's it can be so miserable here. So, all right, let's see here. Let's do this one by Sirius. My family wants to buy me a car after my Chapter 7 is completed. It's already been filed, and I have a lawyer. Can I still own a car after, and what dollar limit is there? So first thing I do, if you have a lawyer, obviously you got to run this by your attorney, because your attorney is going to know all of the ins and outs of your bankruptcy case, local practice. I can tell you this, Chapter 7 is a backwards looking process. What I mean by that is, for the most part, the court's mostly concerned with the day you file bankruptcy backwards. They're not as concerned about assets that you acquire after the filing. And generally, the kind of assets that they tend to look at is like if you get an inheritance within 180 days after you file your bankruptcy. But if you're getting a different car after your Chapter 7's been filed, generally, at least I can tell you in my practice, that's not going to be a problem, and there is no dollar limit to it. It's different if you're in a Chapter 13 bankruptcy. The whole acquiring a car is much more difficult. So, but you need to be aware that after the filing of bankruptcy is generally not a problem. Contact your attorney on that for sure before you take any type of action, because that's something that you need to take a look at. All right. Benny says, can your motion for compel arbitration, if the card agreement states claims subject to our agreement to arbitrate shall not include any claim you file in a small claims court? That's a good question. What you need to look at is where, as far as if they filed the lawsuit, where they filed it. Now, I can tell you, like in states like Arizona, where I'm at, there's different divisions of the courts. There's a small claims court and there's a justice court. Small claims court in Arizona, attorneys are not allowed to practice. So you're rarely going to see a credit card company or a junk debt buyer. They're never going to be able to file, at least in the state of Arizona, in a true small claims type setting. Now, and so I can tell you this, that the arbitration clause is still applicable because they're not filing in small claims. They're filing in justice courts where there's, for cases under $10,000, but it's not small claims. And so unless they've actually literally filed in small claims in your state, then I think you can still demand that that you're arbitrated. Also, I mean, the fact if that's the exact wording that you're putting there, if they're saying that if you file it, meaning you, the consumer, if you're filing in small claims, then it can't go to arbitration. But if they're the ones bringing it, you may still be able to take care, to force the issue there. All right. Name. Reaffirm my home and car in a Chapter 7, received a discharge. Credit report reflects the mortgage as reaffirmed. However, the car loan still shows as discharge. Should I dispute the credit bureau or wait? If the reaffirmation agreement, if you signed it, if the creditor signed it, your lender, your bank, credit union, whoever it is, if you both signed it, and then if the court approved it, so you actually have an approved reaffirmation agreement, then I usually tell people once it's discharged, give it up 30 to 60 days. Let it go through 2 cycles so that everything shows up properly on the credit report. If you file bankruptcy, once it's discharged, you should go through there anyway. Make sure that everything's zeroed out. But if the debt's been reaffirmed, it should show up as the balance there. They should have your payment history, all of that. So yes, you could dispute it through the credit bureau. You may just reach out to your lender and say, hey, well, what's the deal? We reaffirm this. And that's a big reason a lot of people do reaffirmation agreements. I can tell you that it's questionable whether a reaffirmation of a car loan actually provides that big of a credit bump. There's some risk. If you have an approved reaffirmation agreement and then you fall behind on the payments, they can repossess the car and they can sue you for the balance. So, but your question specifically, I would contact the lender first, and then if they don't fix it, I would dispute it with the credit bureau. That is the way that I would go. All right. And so, there's the follow-up. So you just barely received it. So I would give it a little more time. It generally takes at least 30 days to go through the cycle, sometimes up to 60. So there we go. All righty. Well, I think, let me see, that may be it for tonight. We'll do a last call for any other questions that you may have as we head into another weekend. Just want to make sure I got the questions. I think we did. So, I'll go back to this one because this is a good question. This one, if we go back, the question was someone converting from a Chapter 13 bankruptcy to a Chapter 7 bankruptcy, and if they're going to, they have an asset that they're afraid they're going to lose. Can you buy it from the trustee? Generally, I say yes. Most trustees, I think, will work with you on that. So, for instance, if you had, let's say you had let's think cold. Let's say you had a snowmobile, and snowmobiles are not exempt in your state. Like in Arizona, they're not exempt. Let's say it's worth, $2,500. In Arizona, the trustees would allow you to pay them $2,500 or some agreed upon amount. And then they would distribute those funds to the creditors, and then you would keep the snowmobile. So you'd be able to keep that. That has to be approved by the court, but often then the trustees will work out things like that. Sometimes they'll even do a settlement, a discount in trying to get that done. Let me do this one here by Jeff. Can you appeal a judgment against you if you lose? Yes. Most courts have, I should say this, asterisk. Most courts allow you to appeal a judgment, and they'll provide you notice of that. But like in Arizona, for instance, like small claims court, true small claims court, where there's no attorneys, people, and usually it's not even a judge. It's like a hearing officer that's handling your case. There's no right of appeal. But in other courts, there are. The thing you got to know about appealing a judgment, I'll give you 2 things. One, the rules as far as you filing what's called a notice of appeal, which is putting the court on notice that you're appealing that judgment, they're super strict. Like for instance, in Arizona, for the justice court, you have 14 days to file a notice of appeal. Superior court, you have 30 days. If you file it on day 15 or if you file it on day 31, you're done. You're not going to be able to appeal the case. Second thing is when you appeal it, they don't do the trial again or basically do everything over. In most situations, they're looking to see, did the judge abuse his or her discretion in the ruling that they did on your case. So they give the judges some leeway, and what they have to look at is say, did the judge go so far out of bounds that we're going to set this aside. So that's something that you got to be careful with, and be careful of that. So let's end on a good one here with Laura. Laura's been coming each and every week, thanks to you and your course. This is a shameless plug for I have a course on how to compel private arbitration. Thanks to your course and template, the motion to compel private arbitration, Calvary requested dismissal, and your case is over. Awesome. I'm glad that we're able to help. and get that thing out of your life and get it dismissed with prejudice. You got to get it so it's out of your life forever. But I'm glad that helps. All right, we're going to call that for a night. I appreciate y'all checking in tonight. For everybody who keeps supporting the channel, I'm trying to put up a lot of different types of content. I'm doing some of the shorts that are 15 seconds, just to kind of give a little quick information, some of the live content here, and then some of the regular videos. So I hope that that's helpful as you're dealing with these things. Like I always say, it's super stressful, but if you put a plan together, it alleviates a lot of that stress because you know where you're going, you know what your rights are, that there's some ways to deal with this. It's when you don't know or don't have a plan that you're sitting up night just stressing out. That's you need to get over that, get the information you need, and help to move forward. So appreciate you all watching tonight, and we will catch you next week.